Dennis O'Rourke.
Mr Chairman, I want to also ask some questions that I think would normally be asked in a select committee process, but this will have to substitute. I want to particularly refer to clause 6.1, which seems to be drafted in a very broad manner. 6.1 starts off saying every specified bylaw is declared to have been lawfully made and to be always to have been valid despite any one or more of the following circumstances applied to it, and then it gives two such circumstances. The point I'm making here is that the first few words, every specified bylaw is declared to have been lawfully made, before the word and, is very broad. What it actually does is to declare such bylaws to be valid not only for those reasons that are stated, but in fact would make the bylaw valid even if there were other defects in it, in the bylaws, and we don't know whether there are or not. So I would like to draw that to the Minister's attention and to ask him whether in fact the drafting is just a little bit too wide in the way that the words have been used in 6.1. I myself would like to think about that some more, but there won't be the time to do that. There isn't a select committee process, and so that can't really be thrashed out so easily. But I think it's a valid point. If he is satisfied, then maybe I will be, maybe I won't. It seems to me not good wording anyway. The second point I want to make relates to 6.1b, and it refers to the bylaw was made or amended using a process that did not comply with the enactment and so on. And in 2, it refers to any other applicable enactment, and I'm a little bit unsure, as I think it was David Parker or Phil Twyford, I'm not sure. One of the two of them pointed to those words as well and asks the same question. Is that appropriate and necessary in this bill? And if it is, how far does it really go? So I'm worried about that provision as well. I draw that to the Minister's attention too. The next point I wanted to make relates to 6.1c. And I just wanted to point out here that it says, as far as the bylaw was made or purportedly made under the Local Government Act, the bylaw was not reviewed by the relevant local authority, and 2 has been revoked by operation of the section. The point I want to make here is a general one. It's simply that this is a case simply of councils and other road controlling authorities actually not following the law. And it's unfortunate that when people do that we say that's okay, we'll just validate it for you. That actually is a very bad precedent to set. Again, I will admit that there doesn't seem to be any other way around it, but I don't think that this situation should pass without comment in the House. It's not a good situation where local government and other local road controlling authorities can get away with simply not doing what they are required to do, and then to come cap in hand to the government of the day and say, "Oh, fix this up for us, we've cocked up." Not good enough by a long shot. And the last point I want to make actually is a positive one, you'll be glad to hear, Mr Chairman, and that relates to clause 9, the savings for certain legal proceedings. And it says that the Act doesn't limit any proceedings that expressly challenge the validity of an enforcement action on any of the grounds, such as those we've already spoken about, before the date on which this bill was introduced. Now, that's very important. I don't know whether there are, in fact, any such proceedings before the courts, but if there were, it is very important that that provision be there. Not to do so would completely compromise the credibility of our legal system. So I'm very glad to see that those savings are there and certainly approve of that. But I would ask the Minister to think about some of the specific points I've been able to identify. I'm sure that if we had the time to look at the bill in more detail, there might be other points as well. But at least those stand out fairly well for me, and I would appreciate an answer to them.
The Honourable David Parker.
I feel